join us on the program. Mr. Todd Vandermeide, NRA's Illinois lobbyist, is with us. Todd, good evening, sir.
Yeah, I'm on. How are you?
I am excellent. Well, I thought we were going to have you on just to talk about Governor Quinn signing legislation that will protect the identities of firearm owner identification card holders, but we've got breaking news out of Chicago where Mayor Rahm Emanuel is rushing through an ordinance that theoretically would allow for gun ranges to operate in the city of Chicago. Have you seen this ordinance, Todd?
Haven't seen the actual language. It seems that they are redoing what they did when they lost the Supreme Court case in McDonald and rushed through a new ordinance. And that ordinance contained a ban on ranges, even though you're required to get firearms training to get a CFP. So it seems like the anti-gunners were tipped off that this was coming down, and we're in collaboration with the city one way or another. And so they proposed, the ordinance did not get introduced to the city council like most normal ordinances. The mayor used his powers to assign it directly to a committee, and it was heard today at 2 o'clock in the afternoon. And they're proposing to allow ranges, but they have to be 1,000 feet from a hospital, a place that sells alcohol, a school, a park, a hospital. They have to be located in zoning areas for manufacturing. There's some wrinkles here. And it seems that they, different mayor, same MO for the most part, but this is being spurred on because of the challenge by Alan Gura in the ISRA or in the Izal case. There was oral arguments held on it. Well, I'm gonna think a month, 6 weeks ago, or something like that. Mm-hmm. And I think the money shot of the arguments was at the very end of it when Gura was getting up for a rebuttal. One of the justices said, "Mr. Gura, how would you like your injunction to read?"
So go ahead.
They pretty much admitted in some of the news stories this is in response to one of the lawsuits.
Right.
So they're trying to get ahead of it because, let's start tying all these things into a connected dots and tying them into a little package here. The NRA and SAF have won on their motions that the city has to pay our fees in the McDonald and other cases. Mm-hmm. So now they're facing a multi-million-dollar deficit. So here we are. They're trying, I think, to cut out, if we change the ordinance now before there's an appellate ruling, then we get out of paying lawyers' fees. And we're going to keep, going down this road and playing this game of just trying to move the bar, to see how far we can move the bar to where the courts say, okay. But if you go back and get the audio from the appellate court arguments on this, they were even going down the road of what if they make the restrictions so onerous and stuff. So, it'll be interesting to see what happens. Yeah, that's this afternoon's news. We expect the city council in a meeting tomorrow to pass the ordinance, which means it's another one of those 48-hour deals that, they introduce it, they run it, they pass it. But it seems that the city has neither learned from previous court decisions nor our tenacity that we're not going to give up, we're not going to go away. And so sometime this week I will sit down at the computer and I will start writing a bill for preemption. We have a preemption bill on noise levels at ranges and stuff like this, but I guess we're going to have to take that concept just another step farther, and we'll give them something else to chew on and chase us around the Capitol with, and we will continue to have these arguments and how erroneous the restrictions on having a gun range are going to be. So,
Todd, as I understand, this does nothing to address some of the complaints in the NRA's lawsuit, Benson versus City of Chicago, that talk about the prohibition on having more than one operable firearm in the home, prohibitions on self-defense outside of basically your living room or your bedroom or your kitchen.
Right.
They're if they think that this is going to wipe their legal slate clean, they're smoking something.
No, I don't think they're going to. I don't think they see that, but I think they see this as being the closest threat they have to them right now. It's gone up to the Court of Appeals on orals. The orals went. If you always say you never quite know what the judges are thinking, this be pretty cut and dry, that they were not buying the city's argument, that they were. It's a fascinating piece of tape to listen to as to how they treated the city's lawyer over this. So, no. And our lawsuit with, what we were addressing in Benson and what SAF and ISRA and those guys are addressing as well, there are several, there's also Gowder v. City of Chicago, where we've got an individual who's an honorably discharged veteran who was denied their CFP because they have a misdemeanor weapons charge from a decade ago.
Mm-hmm.
So no, I mean, instead of being one big lawsuit attacking every aspect of the city ordinance, there are several lawsuits attacking various parts of it. We've got that, and I think, according to one of the lawyers at headquarters, I'm told that we have more litigation going in Illinois now than we have in any other state in the country.
Oh, really?
Yeah, and, you factor in that SAF has their lawsuit on the UUW statute for carrying a loaded firearm on your person in public. We have ours with Shepherd via the state of Illinois.
Mm-hmm.
So there was an extension granted, I believe, until the 8th. So the end of this week, we got to find out what the state's response to it is. And the Illinois Supreme Court has accepted the challenge to the Cook County semi-auto ban, Wilson v. Cook County.
Wow.
That becomes very important because this will be likely the first time in 27 years since the Morton Grove ruling that the state Supreme Court is going to make a very large pronouncement on the Second Amendment in the state of Illinois. And there's a whole host of issues that are at stake here beyond just, what's in front of us with the semi-auto ban. And this is a McCarthy-style semi-auto ban. It's not the Clinton gun ban.
Mm-hmm.
But in addition to that, I mean, our state constitution, Article 22, says the right of the subject to the police power of the state, the right of the people to keep and bear arms shall not be infringed. Well, we got screwed by that little subject to the police power of the state. And with the home rule powers that are written into the Constitution, they've always said that Article 22 falls victim to the home rule powers. Now, it seems odd that you could have a right protected by the federal Constitution but have that right diminished because of a state constitution. So there's a very large pronouncement that, the court could essentially eradicate the preamble to Article 22 of Illinois' Constitution, and it will be very interesting to see how they incorporate the jurisprudence of Heller and McDonald and start applying it, because the courts are largely, unguided. We've had some bad appellate court rulings coming out of Cook County on this stuff, and we had one ruling where they went down the Dennis Hennigan path saying that, Heller only applies inside the home, which Heller does not say.
Yeah.
And if you go back to part of Heller that I don't have in front of me, but it went on to say, it is no answer to say, as defendants do, that so long as you allow one type of firearm, you can ban others, to paraphrase it. That is directly aimed at Calademos. And Calademos was the Morton Grove case from '82 that went both through our state Supreme Court and through the Seventh Circuit Court of Appeals. And they basically said that so long as you were allowed a type of firearm, a flintlock, your right to keep and bear arms was provided for.
Jeez.
And so, when I saw that language, it struck me completely at the heart of Calademos, which is the controlling law for us in the Seventh Circuit and in the Illinois State Supreme Court. Law that has not been formally touched in 27 years. But now, I believe, as do many of our lawyers, that the United States Supreme Court in Heller drove a stake through the heart of Calademos. And now, when I debated an appellate court judge who wrote one of these horrible opinions, he literally agreed with me that Calademos is dead-letter law. The lower courts simply need our state Supreme Court to acknowledge that formally, and we start on a new path in Illinois. So, yeah, that's we're up to our eyeballs in litigation right now, working on all different aspects of it in the state. And yes, the governor did sign the law that we passed in response to the Attorney General's opinion that the Floyd cardholders' names and information had to be released to the public. Here's the ironic thing about that whole little story.
Yeah.
The AP and John O'Connor has taken the beating for the story.
Why?
Well, that's because they're the ones that got the most infamous part of it. The request really started with the Chicago Tribune. And the Chicago Tribune has never talked about. Every time you've seen an article written in the Tribune, it's been about the AP request for information, not about theirs. We were tipped off to their request for the information, and it was working through that we were working on putting a bill together and working with the state police for them to stall. And then the AP found out about what was going on, and John O'Connor asked me if I knew about it, and I said, yes, I did. And so he had routinely before filed requests, and for whatever reason, he wrote about his request, and it went all over the place, and everybody forgot that it was actually the Tribune that started this whole thing.
Oh, wow. Yeah, I'd forgotten about that. I thought it was the AP.
No, it was the Tribune that actually started it, and the other part of it that was kind of funny was the state police provided us documents where a guy who was behind bars, a convicted felon, was foiling Floyd card information on his victim.
He was submitting Freedom of Information Act requests on his victim?
Yeah. So that was nice to bring up at committee hearings and stuff. But the governor did sign the bill. He signed it quietly over the weekend, which great. We applaud Governor Quinn for taking this stand and signing it pretty quickly, considering we were just out of session 30 days. Normally, the governor has up to 90 days to sign a bill. He signed it relatively quickly. We would hope that this could be a time to impart on, building a relationship with the governor and finding common ground on things that we can work on, and maybe exploring how to change his mind on some issues where we don't necessarily see eye to eye right now. I don't know, maybe 4 justices of the Illinois Supreme Court might be able to persuade him a little bit.
Let's hope. Hey,
or
Todd.
Or a federal judge or 2 out of the 7th Southern District.
Yeah.
Where the persuasion comes from or for what reason, it doesn't really matter. But, we'll give them the opportunity to do the right thing, and see where it all goes. But, even though the legislature is out, it is very fascinating times here in Illinois that, we seem to be, I'm watching the Brady campaign, issue their report about all these failed attempts, and it's like, that's funny. You don't talk about us a whole lot, because Chicago's trying to moot one lawsuit as we speak, and I'm sure that as other ones progress through the chain of events, they're going to try the same tactic on other Chicago lawsuits, and this still may be one of the places where they face the biggest losses, legally.
Mm-hmm.
So there's certainly some fascinating times, because I think with our semi-auto ban, in the Cook County one with Wilson, I think we're probably, positioned fairly well that, the court has accepted it. We're on a briefing schedule. We're waiting for when they'll publish oral arguments. And it's also going to be interesting to see how everything goes. I mean, is VPC, the legal community against violence, how deep are Brady and company going to wade into all this stuff? We don't know yet.
Yeah.
We're watching. But it's very interesting.
All right. Well, listen, Todd, glad you could join us tonight, sir, and we'll keep our eyes on everything going on in Illinois and be talking again very soon.
Oh, I imagine we will be.
I'm sure of that. Hey, Todd, thanks again, sir.